We have a major update in a crucial legal challenge against Illinois' ban on rifles and magazines. The Trump administration has now stepped in and taken a firm stance, arguing that the ban is unconstitutional. Meanwhile, the state of Illinois is pushing back, but instead of directly addressing the issue, they appear to be stalling. Before we get into the full details, if you'd like to support this channel, please consider subscribing and hitting the like button. It's completely optional, but it really helps the channel grow and reach more viewers. And if you find this kind of Second Amendment content valuable, leaving a positive comment below also lets the algorithm know this is something worth sharing with others. Now on to the main update. As mentioned earlier, this is a significant case involving a legal battle over Illinois' restrictions on so-called assault weapons and magazine capacity limits. Recently, the Trump administration filed an amicus brief, basically a legal document offering their support in the case, clearly stating that these bans violate the Second Amendment. Right now, the case is back before the Seventh Circuit Court of Appeals. The state of Illinois is asking that the court overturn a lower court ruling by Judge Stephen McGlynn, who found the ban unconstitutional and sided with gun owners and Second Amendment advocates. In response, the Trump administration is urging the appeals court to uphold Judge McGlynn's decision and recognize that these bans are unconstitutional. However, Illinois isn't backing down. Instead, the state has requested a 30-day extension to file its reply brief. This delay would give them more time to respond not only to the arguments from the plaintiffs, but also to those raised by the Trump administration and other parties who submitted briefs in support of the challenge. To give some background, there were initially several lawsuits filed against this ban. Some district courts granted temporary injunctions, halting enforcement of Illinois' law, known as PICA. But those rulings were quickly appealed, and the Seventh Circuit ended up allowing the law to remain in effect during the appeals process. That led to emergency appeals being filed with the U.S. Supreme Court. Although the Supreme Court declined to take up those emergency requests at the time, Justice Clarence Thomas made an important statement. He warned that if the Seventh Circuit ultimately upholds a ban on rifles that are commonly used by law-abiding Americans, then the Supreme Court should step in once the case reaches a final ruling. His message was clear. The Second Amendment should not be treated as a second-class right. During all of this, while the emergency appeals were pending, Judge McGlynn pushed the case forward at the district level and issued a final ruling. He once again determined that Illinois' ban was unconstitutional. Unsurprisingly, the state appealed that decision too, bringing the case back to the Seventh Circuit. Illinois continues to argue that AR-15s, standard magazines, and related accessories are essentially military equipment and therefore not protected by the Second Amendment. It's the same argument we've seen from other states trying to uphold similar bans. And now, once again, this critical case is in the hands of the very same court, the Seventh Circuit, that has already shown its support for Illinois' restrictions during the preliminary stages. This case took an even more significant turn when the Trump administration, through the Department of Justice, formally entered the legal battle by filing an amicus brief. In that brief, the administration strongly argued that Illinois' law, known as PICA, is unconstitutional. They pointed out that just 3 years ago, the U.S. Supreme Court handed down a landmark ruling designed to put an end to a troubling pattern. Several states had been treating the Second Amendment as a second-tier right, subject to a completely different set of rules than other constitutional protections. Despite that clear direction from the highest court, Illinois moved ahead just months after the Bruen decision and enacted one of the most sweeping bans in the country, targeting some of the most commonly owned rifles and magazines used by law-abiding Americans. By doing so, Illinois directly contradicted the Supreme Court's message that states cannot ban firearms that are in common use for lawful purposes. Now, it's worth recalling that in a previous stage of this case, when the court was reviewing a preliminary injunction, the Seventh Circuit reversed the lower court's decision and concluded that PICA was likely constitutional. But that decision was made early on and didn't represent a final ruling. In fact, the court itself made it clear at the time that its findings were only preliminary. Now that the case has reached a final judgment, the Trump administration argues that there are 3 strong reasons why the Seventh Circuit should reverse course and uphold the district court's decision striking down PICA. First, they explain that several critical aspects of the earlier analysis in the Bevis decision are flawed, even when compared to the Supreme Court's existing Second Amendment rulings. Second, they note that several Supreme Court justices have openly criticized rulings like Bevis in other recent lower court cases, signaling that the High Court is likely to take up one of these challenges soon and address the errors being made in these opinions. Third, and most importantly, the District Court, after conducting a full bench trial, carefully reviewed all the evidence, including expert testimony and factual records. The court found that PICA does indeed violate the Second Amendment, particularly as it applies to semi-automatic firearms and attachments that are commonly used by law-abiding citizens for lawful purposes. Based on all of this, the Trump administration is urging the Seventh Circuit to reverse its prior stance and affirm Judge McGlynn's ruling. One of the central questions in this case is whether the banned semi-automatic firearms qualify as arms under the text of the Second Amendment. The Trump administration leaves no doubt in their position. These rifles, including the AR-15, clearly meet that definition. In fact, the brief highlights that the federal government acknowledges AR-15s and similar firearms are protected under the Second Amendment. The brief even references recent Supreme Court activity, including the Smith & Wesson PLCAA case, where justices such as Kagan and Thomas acknowledged that AR-15s are in common use for lawful purposes. That alone, under Bruen, should be enough to afford them protection. Moreover, the administration argues that AR-15s are not uniquely dangerous and should be treated no differently than semi-automatic handguns, which are also widely owned and used lawfully. The claim that these rifles are military-style weapons doesn't hold up under the Supreme Court's test. They make it clear that this militaristic weapon standard used by the Seventh Circuit has no basis in the text, history, or tradition of the Second Amendment. In fact, historical tradition shows that citizens were expected to supply their own firearms if called upon for militia service. These were the very same firearms they used for self-defense and other lawful reasons. So, the idea that a weapon with potential military utility is somehow excluded from constitutional protection completely misunderstands the original intent behind the Second Amendment. On the issue of magazines, the Trump administration also makes a powerful argument. They assert that PICA violates the Second Amendment here as well. While magazines and other attachments may not be firearms themselves, the court has previously recognized that the right to keep and bear arms includes related tools and accessories that are fundamental to exercising that right. The brief explains that items such as magazines, suppressors, and similar attachments, especially those in common use, are an essential part of the right to self-defense. The administration argues these should be treated as protected arms under the Second Amendment because they directly support the lawful use of firearms. In short, the Trump administration is making it very clear. The bans imposed by Illinois not only defy Supreme Court precedent, but also violate the core constitutional rights of everyday Americans. There are many more arguments in the government's brief, but this gives you a clear picture of how strongly the Trump administration is opposing Illinois' rifle and magazine ban. In response, the state of Illinois has requested an additional 30 days to file their reply brief. Their reasoning? They claim they need more time to respond to the issues raised by the plaintiffs, as well as the points brought up in the Trump administration's brief and the numerous amicus briefs submitted in this case. In their request, the state argues that preparing their reply requires reviewing and addressing 4 primary briefs and 4 amicus briefs, together totaling over 200 pages, far more than what's typical in similar cases. Essentially, they're saying they're overwhelmed and need more time to respond to the volume of arguments presented, especially now that the federal government has taken a strong stance against their law. This looks a lot like another delay tactic by Illinois. But regardless, they are now legally obligated to address the points raised in these filings, including the serious constitutional concerns highlighted by the Trump administration regarding the PICA law. At this point, the case is in the hands of the Seventh Circuit Court of Appeals. And if I had to give my honest opinion, I expect the court may rule just as it did before when it reviewed the earlier injunction. The Seventh Circuit doesn't have the best record when it comes to Second Amendment cases, and they've shown reluctance in the past to apply the Supreme Court's guidance properly, especially the rulings from Bruen and other key decisions. However, it's worth noting that Justice Kavanaugh recently stated that the Supreme Court may soon need to address these kinds of state-level bans, possibly in the upcoming term or the one after. If the Seventh Circuit continues to ignore clear signals from the Supreme Court, this Illinois case might very well be the one that ends up being reviewed at the highest level. The Supreme Court has already referenced this case in recent denials involving similar bans, like the Snope and Ocean State tactical matters. So yes, they are paying attention. If the Seventh Circuit continues on its current path and disregards what the Supreme Court has repeatedly made clear, they could set the stage for a major ruling that could finally settle the issue nationwide. So that's where things currently stand in the challenge against Illinois' PICA law. The state is trying to buy more time, but eventually, they will have to confront the serious constitutional arguments that have now been laid out against their ban. I'll keep following this case closely and will update you as soon as new information becomes available. Thanks for watching. Be sure to like, comment, and subscribe so you don't miss any future updates on this important legal battle.